What happens at a pretrial conference in a divorce case? A pretrial conference is something where there are specific orders of the court that need to take place prior to or on the day of the pretrial conference date. The parties, unless there's a restraining order, are obligated to have a four-way meeting to try and either reach an agreement or at least narrow down some of the issues. On a pretrial date, it's a very important date with the court, and many times the parties are able to reach an agreement and convert the contested divorce to an uncontested divorce and go forward and get the divorce that day. However, even if the parties are not able to resolve everything, usually they're able to resolve some of the issues. The parties are then obligated to update their financial statements, and the attorneys are obligated to do something called a pretrial memo, which talks about what the issues that are agreed upon, what the issues that are not agreed upon, and the different aspects or the different reasoning behind those issues that are not agreed upon. The judge will then look at those memos and sometimes will ask the attorneys to make representations about the issues, and the court will then decide whether or not they can offer suggestions and about ways to resolve the case, or sometimes make referrals to a conciliator, or sometimes to a probation officer to see if you can narrow some of those issues down. Sometimes if you listen to what the judge has to say on the pretrial date, it can make you avoid a costly trial, which will be the same judge that will be hearing the case at the pretrial date is at the trial date. And the judge can give you input about whether or not you are out to lunch or your spouse is out to lunch, or it's somewhere in the middle. And it's very important to listen to what the judge has to say, because it will be the same judge that will hear the case and that will end up deciding the case.